We're here with District Attorney Greg Gambrill. Mr. Gambrill, a press conference moments ago about one of the I can only think one that heads this off any greater than or lesser than would be the Oscar Roy Doster situation, although I think this one beats that. We're talking about Mr. Aaron in his plea bargain. Today, he made a deal with the DA, let's say, but he's going to serve 4 life sentences consecutive. Tell us a little bit about that.
Yes, sir. Well, the one thing I do want to stress is that not only will he be serving 4 life sentences served consecutively, which means one sentence doesn't begin until the first life sentence ends, but the other thing to stress and for people to understand is that he also, to the crimes that he pled guilty to, the fact that under the laws of the state of Alabama, if you plead to a Class A felony that involves, that is a sex crime involving a child under the age of 12, or the production of obscene matter of a child under the age of 17, that you are not eligible for parole, which means that effectively he has pled guilty to life without parole and will die in prison.
One of the things we noticed on the press release that you, the printed press release that was handed out, is unless the laws change.
Oh, yes, sir.
What law could that possibly be?
Well, I mean, if somewhere down the line the legislature decides to say, hey, this is too stiff, we think they should be able to, be paroled. I think it's unlikely because of the nature of this type of crime. It's one thing if it's theft of property and they're looking at prison overcrowding. This isn't theft of property. The only other thing possible is, and this is the same scenario you have with any capital murder conviction, any time of serious crime conviction, there's always a possibility that somebody may challenge the constitutionality of the law. But it's not unique to this one crime, or this one sentence. It is that way in every single criminal case that comes up. That's always a possibility. And so when we make that statement, it's just making just that, us lawyers, we focus on every detail. And so you've got to say that, it's possible someday. Some idiot may decide to change what at this point is a very good, effective, tough law. And if that were to happen, then, so be it. We fight the battle then. But I don't anticipate that happening. This law was just passed in 2005, so I don't anticipate it happening.
One of the things that we've heard of recent, being that elections coming up and you've announced your candidacy, is that plea bargaining has been kind of a big deal with y'all here. Can you tell us the benefit of this particular plea bargain to the families?
Sure. Well, the one thing about any plea bargain is that you don't enter into it because you just want to move a case along. That is the common misnomer, that is the common apprehension that people get, and that's the grumbling that people get, that he's just cutting them a deal, being slack on them, or anything along those lines. The one thing that a district attorney has to do, and it's every district attorney, not just me, it's everyone in the state, it's everyone in the nation, it's everyone in the United States federal system, is that we have to look at a case, we have to look at the strengths of a case, we have to look at what, if this case were to go to trial, what's the chance that there's going to be a conviction? We have to look at the personal background of the defendant. We have to look at the wishes of the victim. We have to look at, if this case went to trial and this defendant were convicted, what's the judge going to do? And we have to look at, okay, let's say they're convicted, they go to jail, what's the parole board going to do? Those are all considerations that you have to take into consideration every time you settle a case. And when you've been doing it as long as I have, 18 years, you got a wealth of experience to draw on in settling a case and coming to a negotiated result of the case. We do our best to try to make sure that any victim is pleased with the outcome. The victim always has input into any plea bargain that we do. Now, in saying that, let's talk about today's plea. This was a case where we sat down with the victims' families very early on in the process. We all agreed that we did not want to have to put the children through it. We knew that if push came to shove, the kids would testify. They're tough kids. They've been through a lot. Their parents love them. They've given them that love, that support that they need. But the fact of the matter is if there was a way to get the maximum punishment without the kids having to testify, we wanted to go for it. Mr. Aaron made it known to the Sheriff's Department that he was willing to negotiate. And so we sat down with the victims' families and we said, look, if we can get a life sentence for each one of your children, for crimes perpetrated on each one of your children, and run them consecutively, he'll never get out of prison. And to the family, every one of them, that's what we want, that's what we want, that's what we want. So for us, it was a very simple task at that point. The victims wanted that. We knew it was the best thing for the kids, and we knew that it would put him away forever, give him the maximum sentence. Even if it had gone to trial, he couldn't serve any longer than the rest of his life. And so it was our goal in negotiating to jump on that and to stand strong and to get that result. And that's what we did.
So plea bargaining, it isn't always a bad thing.
It's never a bad thing. It's never a bad thing. It's something that is done based on the experience of the prosecutor and the experience of the defense attorney. It's as simple as that. The judges encourage plea bargaining. The parole board, the Department of Corrections, everybody encourages plea bargaining. It is a natural part of the criminal justice system in every court in the nation. I mean, when you're talking about handling 500 felony cases in a year, and you got 50 days in that year to get a case to trial, you're going to be talking about an enormous number of cases that are backlogged. I mean, we're talking about cases that wouldn't be tried for 15 years. But when you have a case where you can look at it and say, if this went to trial, this is what he'd get, and we could basically offer that and be done with the case. Why not do it? Or if you have a case where you've got, so there's sometimes strategy involved. You got 3 co-defendants. 2 of the co-defendants are really, really bad guys and were really involved in it. The 3rd guy was driving the getaway car. He was pressured into it by the guys. He's willing to give you testimony of the 2 guys, firms up your case against the other 2 guys. You talk to the victim. The victim's like, yeah, go for it. This is the best thing to do. You cut a deal with that guy to roll on the other ones. Again, that's part of it. That's part of the deal. Drug cases with undercover informants. Sometimes we can cut a deal with a guy to roll over on a bunch of bad dealers. And we can take one guy who's in possession of crack cocaine and make sure that as part of his agreement, yeah, okay, you're going to have to plead this possession, but we're going to put you in rehab. But you're also going to have to make buys against these 10 dope dealers. And so by cutting a plea agreement with one possessive case, we can take out 10 drug dealers. So, I mean, I could go on and on and on and on and on and explain all the various aspects of plea bargains. It's very simple for somebody who doesn't have the experience that I do, that doesn't see cases through my eyes, to be able to stand back and say, oh man, he just let that guy go. Well, that person didn't see the file that I had. That person didn't know the reality of what the court system would do if we had taken it in front of a jury, or if we'd gotten a conviction, what the judge would have sentenced, or if we'd gotten the conviction, the judge sentenced, and he went to prison, what the parole board would do. So those things are always taken into consideration every time that we enter into any type of plea agreement. Again, some people who like to point fingers and say, you know, you shouldn't be doing guilty pleas, are the very ones who've done guilty pleas before, negotiations before. The police officers cut deals, narcotics agents cut deals all the time with guys to work undercover. You know, anybody that points, you know, well, you know, the biblical saying, he without sin cast the first stone.
Let me go ahead in 1 minute or less, and
Yeah.
only for purposes of sitting here. Real quick, if it went to a jury trial, this particular case,
Yes.
there could have been an acquittal. Possible.
There's always that possibility, but I think Wesley Snodgrass did such a
I'm
great
just saying,
job.
I'm just trying to let the folks know that the man could have gotten off
Sure.
with a jury trial.
I mean,
All
there's
right?
always that
The
possibility.
maximum sentence, not death penalty, but life imprisonment without parole.
That's right. He could have gotten a lesser sentence. If he'd gone to trial and been convicted, you know, you don't know what the judge is going to hear that might mitigate the evidence. somewhat, and the judge could have given him a much lesser sentence. I'm not saying that either one of our judges would have done that, because I have full faith in Judge McCath and Judge Short that they would have followed suit.
But he got the maximum of what could have been given out.
Absolutely. He could not have gotten a day more.